For those who don't know me, my name is Warwick Ellis, and I'm the Dean of Law here at the University of Wollongong. And we're really privileged today to have the Honourable Michael Kirby visit us again. After Michael Kirby's lecture, we're going to be hearing from the President of the University of Wollongong Law Student Society, Jessica. Now, this is a very special lecture for UIW.
How long do I have? How long is the lecture for? Do you know?
We've got 1:30 to 2:30. 1:30 to 2:30. So we have about 45 minutes.
Now, I'm not going to give
You can go over should you need.
Mr. Kirby is simply Australia's most famous judge and an outstanding Australian public figure. Mr. Kirby is one of Australia's longest serving judges. He was appointed to his first judicial post at the tender age of 35. And you might not fully appreciate it yet, but 35 is indeed a tender age. Mr. Kirby sat on 3 great courts: the Federal Court of Australia, then he was appointed President of the New South Wales Court of Appeal, and then he was appointed to the highest court of the land, the High Court of Australia, on which he served from 1996 until 2009, just on 35 years. Now, I think Mr. Kirby would have stayed on longer as a judge, if it were not for the fact that the Constitution these days prevents judges staying on for longer than age 70. But Mr. Kirby has continued to work very hard and on all sorts of important jobs. At the moment, he is on a special UN commission. He is chairman of the United Nations Commission of Inquiry into Human Rights in North Korea. Mr. Kirby has been very generous with his time in Wollongong on other occasions and even today. He's already given a talk to local Illawarra lawyers about judicial bullying and the stress that lawyers face. Mr. Kirby was in Perth yesterday. He hosted a dinner yesterday in Sydney, gave a speech. He's already given a talk today. He's giving this class and other things this afternoon, including a special poetry lecture at 5:30. And tomorrow morning, Justice Kirby is on an early morning flight to London to continue his work for the United Nations. Please welcome the Honourable Michael.
Thank you very much, Dean, and good afternoon, ladies and gentlemen. It's great to be back in the University of Wollongong, though I feel bitter and disappointed that I haven't met Adolf, the aggressive duck. I'm told that there are ducks which are sweet and ducks which are kind, and there is one very aggressive duck that pinches students' sandwiches at lunchtime. And I would like to see this duck because I think it might have some instruction for me in my important work for the United Nations about keeping human rights and duck rights in order. So I'm very glad to be here. And I acknowledge the Indigenous people of our country. We should learn in Australia to do this sincerely, as the New Zealanders do, respecting the Aboriginal and Torres Strait Islander people. And if we are lawyers or law students, reflecting on the wrongs that have been done to the Indigenous people by the law, and our duty as lawyers to make sure that the law is brought into line and harmony with universal human rights in respect of Indigenous people and indeed in respect of all people under the responsibility of Australia. I'm very glad to be in the lecture named for Robert Hope. Justice Hope was my colleague in the Court of Appeal of New South Wales, and he was the Chancellor, long-term Chancellor of the University of Wollongong. I used to sit with him on my right and Justice Samuels on my left Justice Hope was the Chancellor of the University of Wollongong. Justice Samuels was the Chancellor of the University of New South Wales, and I was the Chancellor of the Macquarie University in Sydney. So we were 3 Chancellors in the Court of Appeal. And occasionally a barrister would be so stupid as to say, in response to a question which we asked, "Oh, that's an academic point, Your Honours." And we would say to the barrister, "In this court constituted by us 3, that is an inappropriate statement because it's not inappropriate for us to be asking academic questions. What would you expect from 3 Chancellors?" So I honour Bob Hope. He is alive in my memories. He was a very interesting combination of lawyer. He was a very fine black letter lawyer with a great knowledge of property law, which is one of the core subjects that you have to learn to be a lawyer. But he was also a civil libertarian, and he was one of the founders of the New South Wales Council for Civil Liberties, of which I later became a board member, and that opened my mind to the fact that law doesn't always operate justly and fairly to people in our society. And so Robert Hope was a very unusual, very brilliant, very quick, very sharp. He loved the University of Wollongong. He was Chancellor, I think, for about 15 years, and he was here on the very day when he, as Chancellor, received an honorary degree and when the University of Wollongong Law School was founded. And Justice Samuels and I were here that day too. And in my office in Sydney, I have a photograph of the 3 of us together. They were 2 wonderful colleagues in the Court of Appeal and 2 very considerable lawyers. And I was appointed to the Court of Appeal in the year 1984. For 10 years before that, I had been the inaugural chair of the Australian Law Reform Commission. And that had been a very absorbing and interesting task in which I was required to prepare reports and advise the federal parliament and the federal government on the steps that should be taken to improve Australia's law on given topics which were assigned to us by the Attorney General of the Commonwealth. But then in December 1995, I was chairing a committee of consumers for the Court of Appeal in the afternoon. And my brother, Donald, who was a representative of the Law Society, was at the meeting. And I'd been telephoned that morning by somebody from the Prime Minister's department, and he said, "Where will you be at 6 o'clock this evening?" And you know how in the comics a cloud appears above the head of the person, and I thought, cloud, Justice Dean has just retired from the High Court in order to become the Governor-General of Australia. Why would a person from the Prime Minister's department want to know where I am at 6 o'clock? Today is a Friday and that is a cabinet day. Therefore, it is somebody from the Prime Minister's department who wants to know where I am because they might be going to offer me the position of Justice of the High Court to replace Justice Dean. Now, on 3 earlier occasions, or maybe more, I had been passed over in appointment to the High Court, and I thought that my time had passed, and it was a case of always the bridesmaid, never the bride. However, at 6 o'clock that night, I was sitting in the judge's meeting room on level 13 of the Law Courts building in Sydney, and I was trying, as always, to make the Court of Appeal user-friendly, helpful to the litigants, kind and friendly to the barristers, assisting to the solicitors, even appropriately gentle with the article clerks and law students. And then at about 10 minutes past 6, knock, 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 knock on the door. Now that was the first thing that was very unusual, because normally when the judges are meeting there, especially with outsiders, they're never interrupted. And then into the room came my associate, and along came a little post-it sticker. You know, a little yellow post-it sticker, one of the most humble pieces of paper you can ever receive. And it went from one person to another. My brother got it and he passed it on to the next person, and along it came, and eventually it ended up in my hand. Please ring the Federal Attorney General at once. So I thought, this means my life is about to change. And so I mumbled a few words. I got up and left one of the other judges as presiding in the meeting. I went down, I rang the Attorney General, and he said, I have the honour to offer you appointment as a Justice of the High Court of Australia. I then paused for a moment. I thought, will I ask what the salary is? Will I ask about the conditions of labour in this new job? But I thought the better of it, so I didn't ask about any of those things, and I said, I have the honour to accept the appointment and I will do my best. And so, in a whisker, without any parliamentary proceedings, no congressional hearings, no votes by the Parliament, the executive government of the Commonwealth had decided that I should be appointed to be a justice, and so I took up the position, and I immediately set in train the steps to fulfil the office of a judge of the High Court. The actual welcome ceremony didn't happen for me until the following February, on February the 6th, 1996. But before then, and in fact before the end of 1995, I drove down to Canberra. I remember I came on the route via Wollongong, and so I came down with my partner, drove to the High Court building. The High Court building had been built during the time that I was the chairman of the Law Reform Commission and president of the Court of Appeal. So I had never become familiar with the High Court building. I went to the public entrance, I identified myself, and ultimately one of the officers took me upstairs to level 9 in the building. And he took me to the room which was to be my office in the High Court of Australia, my chambers. The room that I was to receive was the room that had been the chambers of Justice Dean. The rooms of the High Court judges in the building in Canberra all have a different wood panelling. My wood panelling, the room that I inherited, was in Tasmanian maple. And so it was a beautiful light-coloured cream wood, a very sunny room. It's the room that looks out from the building across to the old Parliament House and across to the new Parliament House up on the hill in Canberra, and is facing the front entrance, that is to say where the fountain is and where now the National Portrait Gallery of Australia is placed. And when I went in there, I was amazed at the size of the room, because in the Supreme Court building in Sydney, the judges' chambers are adequate, but they're not grandiose, shall we say. Whereas the chambers that I was receiving were very large and had a very long window frame looking out at the two Parliament houses and at the Brindabella Mountains in the background, with all the beauties of Canberra scattered around and all the buildings of the great departments of state. And so I went from the office into a balcony. There's a balcony. Each of the justices has a balcony adjoining their chambers. Not that they spend a lot of time on the balcony. In part, that's because there are very lethal parrots and birds. You have your ducks, Adolf the naughty duck, and we have in Canberra the parakeets and the wild birds which will swoop and attack any judge who dares to come out onto his balcony. It's a very luxurious balcony. There is an office for the judge's associate, there's an office for the judge's secretary, and there's also a kitchen with facilities for entertaining and so on. And all of the judges' chambers on level 9 are built around a core library which is on that level. That core library has the basic books that a judge uses in day-to-day work. There is, of course, a very big library. It's probably the biggest law library in Australia in the building, downstairs on levels 6 and 7, and that has the basic library of the court. But on the level where the judges' chambers are the books which are in regular use, like the Commonwealth law reports, the law reports of the different states, the law reports from England, Canada, South Africa, the United States of America, and so on. And all the textbooks that you need in performing the work of the justices. I picked up a couple of the volumes on the shelf. I picked up volume 1 of the Commonwealth law reports, which was on my shelf. And I opened it, and I saw there the name E.A. McTiernan. So at one stage, that set had belonged to Sir Edward McTiernan when he was a Justice of the High Court. I also saw a dictaphone, which was very useful because I used that at that time, and the dictaphone had a tape on it. So I began the tape to listen to what the tape had on it, because I didn't want to have any confidential material, and I wanted to remove into the archives anything that was important. And I could hear a man's voice droning on about a legal problem. And I listened further and further, and I learned that the voice was speaking about a case which I recognised, and the case was the case of Onus against Alcoa, a case relevant to the law of standing to sue, brought by an Aboriginal applicant who claimed to have a special interest in a matter, and he was alleging that he had standing to raise the question before the High Court, and that was being challenged by the Alcoa Aluminium Company. And I then realised that this was the voice of Sir Keith Aiken. Sir Keith Aiken had been a judge of the High Court before Justice Dean was appointed. In fact, he was the original justice who had occupied the room that I went into in 1996. So that reminded me of the fact that a justice of the High Court doesn't own the room. This is not the judge's personal possession. The justice who is appointed is there for a term of years. The justice is not a life tenant, but has a tenancy of a very small number of years up to the age of 70. And so that brought home to me that Sir Keith Aiken, who by that stage was long since dead, had had his period on the court, and I had to receive my period and to work in those rooms and in an office chambers that were provided for me in Sydney as well, because each Justice of the High Court gets not only the chambers in the building in Canberra, but also in the Sydney Law Courts, or if they come from Brisbane, in the Brisbane Federal Law Courts, or the Melbourne Federal Law Courts, or over in Perth with Justice Toohey and now Chief Justice French. Wherever the base of the judge is, they also have chambers there so that they can work at their hometown, but also in Canberra when they're there. Now, a judge of the High Court doesn't normally live their whole life in Canberra. Justice Dean and Justice Brennan did so, but most of the judges keep their home base and travel down to Canberra, rather like the politicians, and often at the same time, in order to do their duty in the court. And then, after usually about 2 weeks, they go back to Sydney or back to their own home state, and they perform their duties and they work on their judgments in their hometown in the chambers that are made available to them. To understand a day in the life of a High Court Justice in Australia, you have to understand what the court does. The court basically does three things. It deals with special leave applications, which are prerequisite to getting most matters into the court. And that involves making decisions in more than 1,000 cases or applications every year, usually in a configuration of 2 or 3 judges dealing in a panel for that purpose. So that's the special leave jurisdiction. Secondly, a justice deals with the appeals that come pursuant to a grant of special leave. Nowadays, there are no appeals that come as of right. When I was a young lawyer, appeals did come to the High Court of Australia as of right if a certain amount of money was at stake in the case. But nowadays, nothing comes as of right. You don't have a right to appeal, you have a right to make an application for special leave to appeal, and that comes before a panel of 2 or 3 judges who decide whether or not the case is important enough, involves an important enough principle, involves different and inconsistent decisions of the federal or state courts or courts in different jurisdictions of Australia, or for some other reason of justice or legal principle deserves to bring the matter into the High Court. And so special leaves are a very important part of the work of the court. The third business of the court, I mentioned special leave, appeals. The third business is in cases that are brought directly to the High Court, as can be done under Section 75(5) of the Australian Constitution. This is a sort of escalator that allows parties to come straight up to the highest court if they contend that a decision has been made without jurisdiction or has been made in excess of jurisdiction affecting the rights of a person who is complaining about the activities of an officer of the Commonwealth, somebody who's in the pay of the Commonwealth. And that direct route can itself be sent away so that the justices keep control of the matter that comes to them, because if they decide that it's more appropriate, they can send the matter to a Supreme Court or to the Federal Court to have facts found or to have the whole matter tried, so that it then has to come up the appeal process. So they're the 3 areas of jurisdiction, and there are also occasional practice matters about expediting a case or revoking a grant of special leave or sending a matter to another court. These are matters that are dealt with by one justice. Normally, the special leave matters are dealt with by 2 or maybe 3 justices. The appeals are dealt with either by 5 justices, or if it's a big case or a constitutional case, normally with the whole 7 justices, and applications for the constitutional writs can be dealt with by the court as it chooses, normally by 5 justices. And when you arrive in Canberra, I would arrive every Sunday night, and I would find on my desk a huge pile of books. the books would relate to the appeals that were listed for hearing during the forthcoming week. The appeals would be there with the application books for the special leave hearings. The application books for special leave are just as big often as the appeal books, but they have succinct statements of reasons why special leave should be granted, as the applicant will write, or why special leave should be refused, which the respondent will write. And those documents are on the top of the application book for special leave. Similarly, in the appeals, there will be a submission for the appellant, a submission for the respondent, and the answer to the submissions for the respondent advanced by the appellant. So there'll be submissions on top of that. And in many cases, some of these documents have been sent to your home base and have been studied beforehand. Otherwise, you have the whole of Monday in the hearing days to get on top of the beginning of the cases that you will hear during the course of the week. And on the Monday morning, on the Tuesday morning of the week that you're spending in Canberra, the court will assemble before the hearing of the appeal. Appeals are heard in one of two courtrooms. Courtroom number 1 is the big ceremonial courtroom on the ground floor. That's a huge space, and the bench there can seat 9, but at the moment we have 7 justices of the High Court, and the whole 7 justices go into court, led by the Chief Justice or the Senior Justice if the Chief Justice is away or sick, and they go in their strict order of seniority. The order of seniority is established by their commission. The Chief Justice is the most senior justice, and the other judges are appointed in order of seniority. That is to say, they take their seniority from the date that they received their commission. And so you all file it in strict order of seniority. I don't know what would happen if one judge tried to jump the list and go in front of a judge and do so out of order. Such a thing would never occur to a judge, and certainly not to someone who's come through all the ropes and gets to the High Court of Australia. So I never saw that happen, but it certainly would be an unusual event, and it would be talked about for years to come. So that's probably why it doesn't ever happen. And then the justices sit in court and hear the appeal. Some judges are very quiet and ask very few questions. Some judges ask a lot of questions. Justice Michael McHugh was an inveterate questioner. Justice Kenneth Hayne was another frequent questioner, and I was another frequent questioner. I always thought that it was important to ask the question so that the party who was affected by what you were thinking would have a chance to persuade you that what you were thinking, what you were apparently thinking was wrong, and that way to influence the decision that you made in the course of the case. Some judges think it's better just to let the lawyers develop their argument, but the lawyers are there to assist the judges to come to correct decisions, and after a certain amount of time of allowing the lawyers to advance their argument, I think it's usually best for the judges to unburden themselves of the way they're thinking so that the lawyers can answer and put forward their arguments one way or the other. Then at lunchtime, the judges will rise and they will have a bit of a talk about the case and about their impressions of the case and how it is developing. And in the afternoon, after the case is finished, normally nowadays the Chief Justice will offer a cup of tea in his chambers. And so all the judges will traipse into the Chief Justice's chambers. Chief Justice Gleeson was a bit of a health fanatic, And so he would simply have a cup of tea, but he would offer the rest of us, who were very negligent about our health, very large amounts of raisin toast, lathered with butter. And we would tuck into that as we got up our enthusiasm and re-raised our sugar levels so that we could take part in the discussion of the case. And in that discussion, you would sometimes get a clue as to how one of the justices would be thinking in the case. And sometimes the differences in the way the justices would approach the case would come out of the discussion. The same sort of conversation would take place on the following day, and normally a case doesn't take more than 2 days of hearing nowadays. And so that is the appeal jurisdiction. In the fortnight where the court sits, there would occasionally be further discussion about the case, and then in the Tuesday following the fortnight, a video link would be established between the justice's home jurisdiction, that is to say their chambers in Sydney, Melbourne, Brisbane and Perth, being the centres of the current justices, and Canberra, if one of them was still in Canberra, and that would allow the judges to meet by video link and to discuss the cases of the last fortnight. And there would be further discussion, and occasionally it would be pretty clear that either the court was unanimously one way or the other, or that there was a clear majority one way or the other, and then normally the Chief Justice would invite one of the justices who was in the majority, sometimes himself, to write the first draft of the opinion for the court. When that was written, it would be circulated, and sometimes if judges agreed but wanted to have things changed, they would write memoranda to the other judges and suggest textual and substantive and sometimes quite detailed changes. When I joined in other justices' reasons, I often gave quite extensive proposed amendments and suggested changes, and I have to say that normally they were accepted and the changes would be adopted in the giving of the reasons in which I joined. Other judges, perhaps the majority, would simply say, I agree with Gummo J, or I agree with the Chief Justice, and that would be that would be their judgment, and then they would be incorporated into the judgment so that their name would appear as part of the court for the giving of that judgment. And of course, if you disagree either with the decision and the order, which is the most important part of the case, where the judges propose the orders to dispose of the appeal or the process, then the judge who disagrees has to write a separate decision. And that is a burdensome obligation, and unfortunately it was a burdensome obligation that often fell on me, because sometimes I disagreed with the decision, but sometimes I agreed with the decision but did not agree with the reasons. Life is easy if you simply say, I agree. Life is harder if you have to explain why you have a different way of coming to the same conclusion, or if you come to a different conclusion, then in our system you have to justify it. In the European system of law, they don't generally allow dissent, but it's one of the strengths of the English law, which is the system of law we have inherited in Australia, that the judges in a collegiate court have the right and the duty to write their separate opinions if they don't agree with the outcome or if they don't agree with the way of reasoning of the other judges. Now, one of the most difficult and taxing and important parts of the work of the Justice of the High Court is the special leave process, because unless you come through the special leave process, you are dead in the water. So the special leave process is the gateway of allowing a party in or out of the court. There is a brilliant article about special leave I won't tell you who wrote it. It was written by a very distinguished former Justice of the High Court, and it's published in the University of New South Wales Law Journal on maximising special leave performance. And it explains how the judges go about the special leave process, how they get this huge a pile of files on the cases, how nowadays most of the cases are disposed of on the papers, that is to say by written argument, and the judges never hear in open court the argument for the parties. And the panels of the court, there are usually 2 panels or sometimes 3, in which one of the justices is presiding and organises the panel. Usually my panel was with Justice Hayden, and although we had various differences between ourselves about the decision in cases, we very rarely disagreed about whether a case was suitable or not suitable for special leave to appeal. You get a nose for what is a High Court case. You can see that either the amount involved or the issues involved or the principles involved or the potential injustice that is involved is suitable to grant special leave to appeal. And that generally is a unanimous decision. And many of those are dealt with on the papers. If the judges can't agree with dealing with them on the papers, then the matters are referred to another justice who joins the panel, and then it will be decided by a majority, or the judges will order that it be heard in court. And a certain number of cases during the year are heard in open court by an application. It's a very exciting day when you have special leaves. It's generally one day of every fortnight, usually the Friday of the second week. It can take place either at the courthouse in Canberra, sometimes by video link to Darwin or to Perth or to Adelaide or to other cities, sometimes by sittings in other capital cities like Melbourne or Sydney. And those applications are very energetic. About 12 are heard in the course of a day. The barristers have only 25 minutes, 20 minutes plus 5 for argument, and they've got to get their arguments out quickly and try to capture the minds of the justices in order to get the matter decided in their interest. So this is the work of a Justice of the High Court. In the course of the day, I would always try to entertain people. Canberra is a very interesting place, and it has a great flow-through of very interesting visitors. Many of them academics at the Australian National University or the University of Canberra, very distinguished visitors, law professors from the United States and Britain and elsewhere and other parts of Australia. And so I would take advantage of being there to offer lunches and to meet a whole range of people. That's one of the aspects of life in the court that I really miss. Other justices didn't entertain as much as I did, though they would often come to my lunches and they would tuck into the smoked salmon and seem to enjoy it. I miss that capacity to meet such a range of people that I used to in those old days. All of the justices, or most of them, have an apartment in Canberra. Sir Ninian Stephen used to live in University House at the Australian National University, a sort of college environment. But most of the justices have an apartment. I had a very nice apartment in Kingston, which was on the top story of an apartment block with a wonderful view of the city. My partner Jan would come down every sittings and he would be there, and we would go for a walk. Canberra is a really beautiful city with wonderful stars at night magnificent clear skies, and I would walk to and from the court in the morning, a very nice way to clear your head. I would start normally at about 6 a.m. and I would go home normally at about 7:30 p.m. So the days are long, but they are interesting. The work, of course, is the highest level work of the legal profession of Australia. And what I would tell visitors who came to the court was that although we in the court occasionally had our differences about the outcome of cases, I never doubted that the other justices were acting with complete integrity according to their values and their understanding of the law, and that in Australia the judges are not corrupted. They are making their independent decisions in accordance with law and as they understand it. So that's a sort of brief resume of life in the High Court. Do I miss it? No, I don't really miss it. My life has been one in which for about 10 years I've done different things. 10 years as a solicitor, 10 years as a barrister, 10 years in the Law Reform Commission, 12 years in the Court of Appeal of New South Wales, 13 years in the High Court of Australia, and now most of my life is taken up in United Nations activities and activities for the international community, the Commonwealth of Nations and other organisations, and some arbitration and mediation, and speaking at conferences and coming to law schools. So every decade has been different. Life shouldn't be boring. People should move on, get different challenges, and certainly that is what I've been privileged to do in my life. So that's basically imagining the day in the life of a High Court Justice. As Justice Dean once said, it's important constantly to tell yourself that to be a judge of the highest court of a not terribly important nation in a tiny blue planet, which is a completely insignificant planet in the solar system, circling around one of the most unimportant stars in the solar system, part of the most unimpressive galaxy of the solar system, in the middle of a universe with 1 billion galaxies, is not a big deal. You have to understand that in our human lives, our achievements, though we strive and struggle to make them, can only ever be bounded by our human potentiality. The most important thing I have done in my life, I think, is not being chairman of the Law Reform Commission. It's not being president of the Court of Appeal. It's not being a justice of the High Court of Australia. It's not being chair of the Commission of Inquiry on Human Rights Violations in North Korea. The most important thing I've done in my life, I think, is having a loving relationship with my parents, with my siblings, and with my partner, and having that as an anchor for my life. That is often a challenge for lawyers, because lawyers are under huge pressure to deliver and to perform. But the most important thing in life, basically, is in the personal dimension. And everything else is a sort of decoration for the activities of the personal dimension. And so it's on that note that I'd like to finish. Keep your work-life balance in order, because it's often challenged by the sort of life that the law provides to its practitioners. Well, we can now have a big round of applause, and then we'll have some Q&A. Okay, that's enough. That's enough. Are there any questions? Now, we've got roving microphones, and this is an opportunity for you to ask. If you've got a particularly difficult essay and you need a little bit of help or inspiration, if you've reached a mental blank, on the essay. You can ask a question, but this is your chance. Yes, there's a question here in the front.
Mr. Kirby, you were a very influential judge when you were on the High Court, and you're still a very prolific figure. And I think a lot of your judgments and your dissents as well has made you almost a celebrity, a bit of a cult figure. How important do you think it is for judges to be vocal and be passionate about the issues that they see as really important? For example, with gay rights, you've come out and you've been so vocal and so influential in that realm. Do you think that there are a lot of High Court justices that sort of almost keep that sort of thing to themselves? Do you think that's important to be?
Well, don't forget that I had a rather unusual career going through the Law Reform Commission, and therefore I had a decade in which I was involved in legal policy, and I was involved with media, and that was just part of that particular job. And I was very careful in the matters that I would talk about, because you have to avoid issues that might come before you in the court. And passion is a word I respond rather negatively to, because I think it's very important for judges and lawyers to keep their hearts and their minds in harmony, so that they're not just out there passionate and wild about a particular issue. But if the matter involved the administration of justice, then it's not improper for a judge to talk about it, at least in general terms. During my time on the High Court, I didn't talk very much about the issues of gay rights. That's something that I felt able to talk more openly about since I left the court. And it does need to be talked about, because it's really distressing that in a country which boasts of a secular parliament and as a secular principle, that full equality of rights is not accorded to a small proportion of the population simply because of their sexual orientation. So you wouldn't want every judge to be rabbiting on about issues that they want to talk about, but I was always very careful to basically confine myself to matters that deal with administration of justice and the rule of law and fundamental human rights. And I was also careful to avoid talking about matters that might come up before the High Court and might cause me to have to recuse myself from sitting in a case. So I think that's the answer that I would give. There are some matters where judges should talk up. Hitler's judges, when he came along, all the Jewish judges were sacked immediately, and the judges of Germany said not a word. The only time that the judges in the Third Reich ever raised their voice against the Hitler government was when a move was made to reduce their pensions. That's when they spoke up. And I don't think that's an appropriate criterion for judges speaking up. I think it's important for a judge of the High Court to explain his or her job. And I think it's important for a judge of the High Court to tell the citizens how they make their decisions. And important to explain that decisions are made not just by words, but involve values, and that the values are inculcated in you very early in your life, and including in your time at law school. So they influence decisions. Judges are not on automatic pilot. I also think it's important for judges to tell the citizens that the judiciary is not corrupted, that it is an independent, neutral organ of government where the judges do their best to reach their decisions in a principled fashion. They may disagree, but then that disagreement is made clear to the public, and I think that's a good thing too. Any other questions? can't hear.
In a recent interview with Margaret Crossley, you briefly said that you were not comfortable with the nickname and sobriquet of being the great dissenter, and that you were not comfortable with the nickname of being the judicial activist, meaning, of course, that you were a minority of one in a supposedly conservative court. I just wonder whether you'd like to elaborate more on that, because I don't think you spoke very briefly about this in the interview. Would you like to elaborate on your feelings about these descriptions that people have made of you?
Yes, well, if you actually look at the decisions that were made during my time on the High Court, overwhelmingly they were in agreement with the other justices of the court. If you add the special leave decisions, which are truly important decisions, unless you get special leave, you don't get into the High Court, so your case disappears. And if you add all of that, then the number of cases where there were disagreements was relatively small. And in fact, the surprise is not that they were, in my case, about 1/3 of the cases, but the surprise is that there were not more of other justices who disagreed, because a case doesn't get into the High Court unless it is the type of case on which you can have genuine disagreements of decision. If there's no disagreement, and if the law is absolutely clear, and if there's no reason to disagree, the case shouldn't get special leave and shouldn't be troubling the justices of the High Court. So that's why I think the great dissenter and the judicial activist is part of a media spin to try to disempower a justice. And I don't agree with that. If you asked me, I would say one of the most activist decisions of the High Court of Australia in my time was the work choices case. That was a case which threw aside 100 years of decisions relating to the power under section 5135 of the Australian Constitution for the handling of interstate industrial disputes, and said, well, we needn't have ever bothered with any of that because it could all be done under the corporation's power. And that was a line of authority which was completely different to what the High Court in 100 decisions had held over more than 100 years. So if we're talking about judicial activism, I think that was very activist. I dissented in that case. But it isn't really helpful to use phrases of that kind, because basically they're insult phrases and they're designed to, as it were, take the mind of the citizenry and the readership and the legal profession away from the reasoning in the case, with which one can agree or disagree, and to simply say, well, that's a wrong decision and it's tainted by activism. Is there a question right up the back? Where is the microphone, please? Do you still have the mic? Right, okay.
Thanks, Mr. Kirby. In the High Court, are there any particular cases that you presided over or judgments that you've written or been involved with, dissenting or otherwise, that you found particularly fulfilling personally, and why?
Well, I may be crazy, but I found them all fulfilling. I know that sounds a very sort of naive view to take, but I enjoyed my time on the High Court, and even though it was very hard work, and particularly because I often disagreed either with outcomes or reasons, I found it very interesting, because I am very interested in legal doctrine and legal theory. And the High Court is the ultimate court of the nation, and it does permit a judge of the High Court to explain what motivates them and gets them to a particular conclusion one way or the other. I do know that in law schools, my reasons are often used. Justice Mason, former Chief Justice Mason, said that if you really want to know what a case is about, you start with the Kirby reasons, because the fact is that I needed to explain what on earth the case was about to myself, because if I didn't do that, I would not be able to approach honestly the resolution of the problem. Now, different judges had different ways of explaining decisions, but I think if you want to know what the case is about, and particularly if you want to know its social setting and the setting of the problem in the whole content of the law, then as Chief Justice Mason said, it's usually a pretty good idea to start with my reasons. Don't ignore the other reasons, but at least start with mine. Any other questions up here? Yes. Excuse me. Okay.
So it might be a bit of a silly question, but I was wondering, when you started law, did you ever think that this was where you were going to end up as one of the most sort of well-known High Court judges and one of our favourites?
Well, did I ever stop to think I might end up on the High Court of Australia? Well, I suppose you dream about what would it be like. I often ask myself, you know, imagine a day in the life of a Justice of the High Court. So I sort of imagined, now what would Sir Frank Kitto do with his day? Well, apart from gobbling up a few barristers in court, because he was a very, very sharp and brusque judge, something I never was, he had lived a rather narrow sort of life, whereas my life has been engaged in a lot of things, and as I've said to you, every 10 years I've done something different. So I think, did I dream that I might one day become a Justice of the High Court? Well, maybe I dreamed about it, but I didn't stop and think about it too much. But it is very important to get involved. I became a Justice of the High Court because even at law school, I got involved. I became a student troublemaker. I became the president of the Law Students' Law Society. I went on to become a member of the SRC. I became the president of the SRC. I became the president of the union. And I then became a member of the Council for Civil Liberties. Don't just sit there at home and watch the television. Don't just sit there at home and think of number one and how unfair the world is to you. You've got to get off your backside and do things for other people. And the Council for Civil Liberties, I got an email yesterday saying they've opened the positions on the Council for Civil Liberties for election. I was thinking I might go back and join them again and become the president of the Council for Civil Liberties. But get involved. Don't be boring. The world is full of very boring people. It's very important to be active, to be engaged, to be doing things for people less fortunate. And there are plenty of them in our world. Back in the old days, when I was on the Council for Civil Liberties, we were defending the students who were conscientious objectors against the Vietnam War, or students who went on the bus rides to Walgett and to Moree to support the Aboriginal students in those places. So we were getting out and doing things and not being boring, and that's very important for you to do if you want to have a full life and if you want to be noticed. And it's getting noticed that got me on the High Court of Australia ultimately. If you just keep your head down and look after number one, well, that's a good life, but you won't end up working 24/7 like I do.
Judge, on behalf of all the law students of the University of Wollongong and also the high school students...
Oh, isn't this beautiful?
we have to present you a UOW Law hoodie.
Oh, I love it.
So you can wear it on those long nights when you're working just like we are in the library.
Yes, I will be. I'll be working long nights in the library, yes. And it's isn't it a beautiful colour? It looks wonderful. Looks like the magpies. It's great. Thank you very much.
I'll take that, Jodie. Thank you so much. Thank you.
legislation is for a country.